Mr. Arun Jaitley, Honorable Union Minister for Finance, Corporate Affairs and Information and Broadcasting, Chairman of the Institute of Companies, I'm sorry, my throat of all the days today is giving me a lot of problem. Institute of Company Secretaries, Managing Director of the Bombay Stock Exchange, and ladies and gentlemen. Yes, I'm not going into the nitty-gritties and nuts and bolts of the Fslrc report or the India Financial Code. There is a technical session, and I'm sure qualified people will debate it and put the nuances across to you. I shall only give you a broad overview of why was it necessary to bring into existence such a code and what it hopes to achieve as a result of its coming into existence. My thanks are due to the organizers of this seminar for giving me an opportunity to address the gathering of professionals, practitioners, and other eminent people in the field who have come here today to meet and share knowledge regarding the India Financial Code recommended by the Financial Sector Legislative Reforms Commission, which I shall be calling the Commission or Fslrc for short, which gave its report sometime last March. I'm happy to be here today to speak to you about an important component of economic development that has engaged even the attention of the President of India as reported on the front page of Indian Express yesterday. As all of you are aware by now that there are 9 key components of the legal framework recommended by the Commission. They are consumer protection and competition, microprudential regulation, resolution, systemic risk, capital controls, development, monetary policy, public capital controls, public debt management, and foundations and contracts of property. I will not dwell on the nitty-gritties as I said, but let me go straight and give you a flavor of the recommendations and what it seeks to address. The principle of consumer protection is an important determinant of the way governments and regulators think about their job. It is part of the invisible legal architecture that frames our choices and shapes our lives. And yet, very few regulators have a precise understanding of what constitutes consumer protection. Some believe consumer protection is best served by holding financial literacy camps. Others believe consumer protection is best served by an ombudsman or by setting up an investor protection fund. While one cannot gainsay that these are important activities, consumer protection is much larger and requires an attitudinal change towards regulation. Since there are no precise definitions of consumer protection in the existing law, regulators claim the flexibility to do many things and some necessary and many not under the garb of consumer protection and claim that the regulated should have a healthy respect towards them. Also, because consumer protection is not precisely defined, many regulations framed by regulators do not do enough to protect the consumers. Moreover, in a developing country like ours, regulators often feel the need to develop the market and in their enthusiasm inadvertently establish low thresholds of consumer protection. The need of the hour is for clearly identifying what constitutes consumer protection in the field of finance and what tools the regulators should develop to protect consumers. You know, I was fortunate enough to be associated with the Commission as its chairman, and its report is already in the public domain. The Fslrc and its members spent 2 years of intense research, consultations, deliberations, and drafting, supported by a technical team of more than 30 people. In all, 146 people were involved in the Commission's work, including lawyers, economists, and other domain experts from India and abroad, bringing with them decades of accumulated experience in finance, regulation, public administration, and law. The aim of the Commission was to examine the foundations of the Indian financial system, raise fundamental questions unasked hitherto, attempt answers to them, and recalibrate the financial system to align it with the aspirations of a liberal democracy, namely that it should be open, transparent, and governed by the rule of law. The Commission's work involved asking difficult questions about the purpose of regulation, the role of the state, and the checks and balances required to make the system fair and accessible while being efficient and effective. Though the report of the Commission was released last year, along with the draft Indian Financial Code, the work started by it is far from over. For such an area as this, it is important opportunity to continue those debates in the public domain. These are debates about democracy, fairness, and justice as much as they are about the incentives, systems, and signals. That is why it is so important for all of us to dispassionately participate in such a debate so as to arrive at a consensus unhindered by the drag of status quoism. There were a number of critical topics that were discussed during the writing of the Fslrc report, and consumer protection was an important one. All financial laws in the country are intended for the consumers, and regulators are the arms of the state to ensure that the benefits reach the ultimate beneficiaries. The Fslrc report recommends a decisive move away from the old concept of caveat emptor or buyer beware towards seller beware regime. In such a regime, financial service providers must assume greater responsibility and care when recommending or selling products and services to consumers. This move is motivated by the realities of modern financial services on the one hand and the realities of an emerging market like India on the other. The deleterious consequences of a buyer beware approach is seen by us in real life today all around. When consumers are duped on a mass scale by private entities within a buyer beware attitude to regulation, there are few efficient mechanisms for recompense to the consumers. Consequently, there is an overreaction from government agencies who go into an overdrive and do overkill by banning entire sectors of economic activity. We thus get caught in an adverse cycle of under-prosecution and overreaction. We must surely ensure that the baby is definitely not thrown out with the bathwater. As a general experience, financial service providers are in a position of massive bargaining power relating to all but their largest clients. Consumers are generally less informed about finance and the financial firms, and typically not able to band together to defend their interests. India is an emerging economy. It cannot be taken for granted that all consumers are well informed or free to or reject a contract that which they feel is unfair. The Commission therefore recommends a system-wide commitment to consumer protection in which all regulators build relevant protection into their respective regulations. One critical priority is to mandate that financial service providers make clear, adequate, and relevant disclosures to the consumer and to ensure that, based on the consumer's expressed needs, the product or service that is being offered is suitable for that particular consumer. Allow me to remind you all of the critical role you have to play as you work to bolster development in making that development more rule-bound and fair, and thus less fragile than if it were to come at the expense of the Indian consumer. Let me turn a moment to the broader debates I alluded to earlier about the fundamentals of a democratic system. Financial regulation, inasmuch as it is regulation, that is the application of the coercive power of the state to private parties, is not easy. As we pointed out in our report, and as any regulator would readily agree, regulation is technical work requiring care, attention, and expertise. It is precisely because of that complexity that we have created regulators in the first place. Specialized bodies who will accumulate knowledge and human capital and will build institutional knowledge and physical infrastructure and information networks that allow them to rise to the challenges at hand. In order to be effective, regulators must have the legal mandate to formulate rules, to allocate resources as they see fit, and to act decisively. All this contributes to an environment in which private parties can operate freely and with clarity and confidence. I mentioned how we work to strike a balance and design a system that is fair and accessible while being efficient and effective. Striking this balance is complicated because many of the things that we do to make regulators more effective also diminish their accountability to Parliament and to the people at large. After all, we cannot forget that regulators, like the state that they represent, are for the people and not vice versa. The problem is that we have created regulators that function as mini-states. In our larger constitutional framework, we have separated the critical functions of the government, like legislative, executive, and judiciary, and placed them with separate bodies. This system of checks and balance is meant to prevent the government from acting outside the purview of the law. When we create a regulatory body, we often find it necessary to give that body an ability to write regulations, conduct investigations into the violation of those regulations, and adjudicate on the violations afterwards. One partial solution to this is to at least separate out those functions within the regulator and assign separate staff to carry out each of these functions. Let us take the case of adjudication. When the investigation staff of a regulator takes action against a regulated entity, they must provide it with an opportunity for a hearing before a regulator. When it appears before a regulator to represent its case, it should not be before the investigation officer himself, but someone who will act as a neutral third party. That requires building a separate adjudicatory capability within the regulator with dedicated staff, probably headed by an administrative law member and staffed by lawyers. The person hearing the case should show no bias toward the investigation staff. He needs to be able to give a fair hearing and, if necessary, decide against the investigation officer. It is difficult to build this internal separation of power, but it is absolutely critical to the rule of law. The game must not be rigged at any cost. It has been argued that the internal safeguards are the only ones that are required to ensure that regulators remain within the bounds of law and that any interference beyond that will compromise their work. It is argued that the work of regulators is nuanced, esoteric, and complicated, and that the regulators need to preserve flexibility and freedom of action to respond decisively to events in the world. Under this view, there is a fear that judges will second-guess the actions of regulators, which is a short step from encroaching on the domain of policy making. We in the Commission disagree with this. We believe that in a democracy wedded to the rule of law, no one, not even a regulator, is above the law. Our response to the difficulty of building checks and balances in a specialized area of regulation is to build a specialized mechanism, not to give up on checks and balances. The proposed Financial Services Appellate Tribunal would fulfill this role. It needs to be and will be staffed by personnel with relevant domain knowledge and expertise, training and experience, and it is designed to adjudicate openly, efficiently, and in an informed manner disputes between regulators and regulated entities. Yes, one can argue that the new tribunal will not have the institutional knowledge required to appreciate the subtlety of a regulator's action and rule fairly. But the first thing to keep in mind is that the regulator must be able to explain its actions. It can explain its actions to judges of the High Court or Supreme Court. If it can do so, neither of whom can claim to have expert knowledge. It can surely explain its actions to a tribunal that can lay claims to such expertise. The second thing is to keep in mind that institutions evolve, and they evolve together through their interaction. Sometimes that interaction may not be smooth, but may involve some tension. But that is the point of checks and balances. Healthy tension between institutions is what makes a liberal democracy tick. In the years since the Securities Appellate Tribunal was set up to hear appeals from the SEBI orders, the quality of SEBI orders has increased, and so has the quality of SAT decisions. Regulators should take comfort in this fact. Thankfully, the independent academician Dr. Rajan also disagrees with the RBI Governor Dr. Rajan on this aspect. In his 2009 report, 100 Steps, Dr. Rajan wrote, and I quote, "Regulatory action should be subject to appeal to the Financial Sector Appellate Tribunal," unquote. Thus, this is the thinking that guided the FSLRC's deliberations, and it is the position we still take today. Allow me to share a few thoughts from the experience of the FSLRC. Those of you who have looked at the Commission's report, and I think a professional body like this is fairly familiar with the report by now, will know that it has recommended reorganizing India's financial regulatory architecture. Probably we were doing this Swachh Bharat campaign in the field of financial laws, which the Prime Minister is now doing with respect to the cleaning of the streets of the city. Again, it is a topic that may easily get passed over by many people as esoteric, but all those who are connected with the financial field, as such, you would acknowledge that it will profoundly affect the Indian financial ecosystem. What is the logic behind this reconfiguration? The proposed regulatory architecture allows regulators to look beneath the surface of a product or service and unmask it to its essentials, be it termed as a loan, an insurance scheme, or an investment, and regulate it according to the risk it poses to the system and the probable risk that a firm may not fulfill its promise to the consumer. I fear that criticism of the proposed framework glosses over this critical argument, which is actually about more than just operational synergy. It is the result of soul-searching, rethinking of the way we draw the lines around the various kinds of financial activity and compartmentalize them, leading to avoidable turf wars, which is one of the objectives of avoidance as far as we are concerned. It is driven by a more agnostic view of risk management, both at the systemic level of individual firms. It is indeed to underline the consumer as a focal point of the debate. Finally, it is a leap. Is this a leap into unknown territory? Hardly. This is the approach that the UK had implemented already, and yet it is a bold move as far as we are concerned. But this is one that the Indian financial sector and the Indian consumers deserve. Our financial architecture has become unwieldy and unresponsive. Provisions that were intended to be temporary, like the RBI Act of 1934, is a glaring example, that have become permanent. Sometimes this is the result of inertia rather than careful planning. Arrangements that were the best we could have done at the particular time now appear to be the only way to do things. One fears that as a result, parts of our regulatory machinery have become brittle, fragile, or worse, completely irrelevant and utterly useless, if not downright harmful to our own interests. It is this concern which motivated the proposed reforms. This is not change simply for the sake of change. And indeed, what we proposed is far from cosmetic. This is fundamental re-engineering of a sector that desperately needs it. To push ahead with our current arrangements and simply hope for the best would indeed be reckless despite our known reliance on jugaad. We must reform in anticipation of future. We must reform in anticipation of future crises, not only in response to past ones. There is a famous saying in Sanskrit, it says, Yuddha kale shastrabhyasaha. The military does left, right every day so that they are prepared when the crisis hits them. If they start doing left, right when the enemy is at our doors, you know what will happen to us. Our preparedness for the future requires that our institutions and our systems must be world-class when we expect the GDP to be in the region of about 20 to 30 trillion USD in about 15 to 20 years. And we entertain the ambition to be one of the leading players in the world's financial area. Only legislation can drive institutional change to yield the high-performance institutions that we need. Change is necessarily disruptive because hence people abhor change. Reform unsettles the powerful, hence it ruffles feathers. But it is necessary and it must be done now. As I always said, you can't run the Monte Carlo race with an ambassador car, however well-served the ambassador car may be, however much I may be in love with my ambassador car. Thank you, ladies and gentlemen. There is it for you.